Hello and welcome. We really thank you for attending today's webinar. I have online here with me Julie Ludwig, our marketing coordinator. Wave Julie there, thank you for helping organize this and get this together, and attorney Luke Goodrich, who I will introduce in just a moment. My name is Travis Chepkema. I'm president of Church and Casualty Insurance Agency, and like I said, we're glad to have you. Religious freedom is a hot topic amongst religious organizations, and we like to address issues our insureds are talking about. So with that said, I would like to state that Mr. Goodrich is speaking today on his own accord and not on behalf of the agency. Also, Mr. Goodrich today is only providing legal information and not legal advice. Finally, this webinar will not get into insurance coverage related to religious freedom. We provide coverage for religious freedom, and we'd be happy to talk to you about that one-on-one. Mr. Goodrich's presentation will be approximately 45 minutes, and we will have 10 to 15 minutes for Q&A. You can use the private chat feature to ask your question, and we cannot promise we will get to all of them, but we'll get to as many as we can at the end. I would ask that you keep your questions specific and brief. Okay, so now that's all out of the way. Mr. Goodrich, Luke Goodrich, is the author of Free to Believe, The Battle Over Religious Liberty in America, and vice president and senior counsel at the Becket Fund for Religious Liberty, where he has won multiple Supreme Court victories for clients like Little Sisters of the Poor and Hobby Lobby. He frequently discusses religious freedom on networks like the Fox News, CNN, ABC, and NPR, and in publications such as the Wall Street Journal, USA Today, and Time Magazine. He also teaches an advanced course in constitutional law at the University of Utah, where he lives with his family and enjoys exploring the outdoors and serving in their local church. Before Mr. Goodrich takes it away, I forgot one little item, and that is this is being recorded. So just to get that out of the way, we will record this webinar and post it later. So with that said, Luke, thanks for being here, and take it away.
Great. Thank you, Travis, for that kind introduction. Very excited to be here with you all today. As Travis mentioned, I'm Vice President and Senior Counsel at the Becket Fund for Religious Liberty. Becket is the nation's premier law firm dedicated exclusively to protecting religious freedom and to protecting religious freedom for people of all faiths. And so I spend most of my time litigating high-profile religious freedom cases in courts across the country. And as Travis mentioned, while I am a lawyer, I'm not here to provide legal advice. I'm just providing you with legal information. And the title of my talk today is Religious Freedom for Houses of Worship, the Good News, the Bad News, and How to Prepare. And I have three basic goals for our time here today. Number one, I'd like to start with the bad news, what I think of as emerging conflicts involving religious freedom for houses of worship. And there's obviously a huge number of religious freedom issues that houses of worship face, from land use disputes to COVID regulations. But one of the biggest emerging conflicts we're seeing today is between LGBTQ rights and religious freedom. So I'm going to focus mostly on those emerging conflicts, not because those are the only ones, but those are the ones that I get asked about the most often. And they are in some ways the newest, because we're seeing conflicts there today that we couldn't have imagined 5 to 10 years ago. So first up will be just kind of a 30,000-foot overview of emerging conflicts between LGBTQ rights and religious freedom, particularly for houses of worship. And then second, I'd like to cover the good news. And there is a lot of good news, strong legal protections for houses of worship and a good climate for religious freedom in the court system today. And then third, I'd like to talk about how to prepare, because part of the good news is you as a leader of a house of worship or a member of a house of worship, you don't have to just sit there and wait like a sitting duck for religious freedom conflicts to come to your doorstep. There are practical steps you can take to reduce your risk. And so by the end of this talk, I hope to give you at least prime the pump, give you a few practical steps that you can take to reduce your risk. So with that, let's jump right in. First up, the bad news. What are the emerging conflicts, religious freedom conflicts we're seeing for houses of worship? When I think about the conflicts, I think it's useful to have a sort of a taxonomy, a schema for thinking about the types of conflict that we're seeing across the country today. And I think there's two main types of conflicts. First up are private lawsuits. This is where a religious organization is out in the world, is engaging in conduct, and they somehow offend or aggrieve an individual or a group of people. And that individual or that group brings a lawsuit. They sue the religious organization, alleging that the organization has violated some law. That's probably the most common type of religious freedom conflict and the one we're most familiar with. And then the second major type of conflict that we see is what I call government penalties. And this is where the federal, state, or local government doesn't wait for an aggrieved individual or group to bring a lawsuit, but instead the government on its own initiative deems conduct by a religious organization to be unlawful or against public policy and imposes penalties such as the denial of government funds or the denial of government benefits before any lawsuit is ever filed. Private lawsuits, government penalties, these are the two main types of conflicts that we're seeing today. And let's delve into some of the details. So what are some examples of private lawsuits that we're seeing today? One of the biggest areas has to do with employment laws. So just to take one example, I'm currently litigating a case called Starkey versus Archdiocese of Indianapolis. And the Archdiocese of Indianapolis, like many religious organizations and houses of worship, operates a number of religious schools. And pictured on the side there is Roncalli High School. This is a Catholic high school that's a ministry of the Archdiocese of Indianapolis. And like all Catholic schools, Roncalli expects its teachers, its administrators, and its key employees to adhere to and uphold Catholic Church teaching, both in their lives and in their conduct within the school. And the Archdiocese has been very careful in all of its employment contracts with workers at the schools. It lays out the requirement that employees be supportive of the Catholic Church and its teachings, lays out specific conduct that can put an employee in breach of contract, and lays out various remedies. One of the requirements in all employment contracts in the schools with the Archdiocese of Indianapolis is that employees can't engage in sexual conduct outside of male-female marriage. This has been clear in their contracts for many years. Very recently, Roncalli had two different employees, the co-directors of the guidance department, and they entered same-sex unions in violation of their contract and in violation of Catholic Church teaching. And so at the end of the year, the Archdiocese politely informed them that because of this breach of contract, their contract was not going to be renewed for the following school year. Now, both of these teachers have filed lawsuits against the Archdiocese seeking over $1 million in damages. If this had happened 5 years ago, these lawsuits never would have gotten out of the starting blocks. Federal law was uniformly interpreted not to prohibit employment discrimination on the basis of sexual orientation or gender identity. But as you may have heard, last year, the Supreme Court, in a case called Bostock versus Clayton County, dramatically expanded the scope of federal employment discrimination laws and said that those laws do cover discrimination on the basis of sexual orientation. So whereas these lawsuits would not even have gotten out of the starting gate 5 years ago, the court has allowed these lawsuits to get off the ground. And now the question is, what are the religious freedom protections for the Archdiocese of Indianapolis? So that's just one example of one of these private lawsuits in the area of employment. Another key area where we're seeing emerging conflicts manifesting in private lawsuits is what I call public accommodations. This is where a religious organization is out in the world some way, providing goods or services to the general public, and someone in the general public is offended by the way that a religious organization provides those goods or services and sues. And we're seeing this in a variety of areas. First up is wedding vendors. This is probably the most familiar area for the general public. These are photographers, bakers, florists, business owners who serve all customers, but cannot in good conscience provide their services in support of a same-sex wedding. We've seen a number of cases, including one for a cake artist that went all the way to the Supreme Court. But these public accommodations lawsuits are not at all limited to for-profit businesses. We're seeing them in a number of other areas. One is meeting spaces. There's a case in Oregon right now where a church owns a meeting space and rents it out for events. But the church cannot in good conscience rent out its space for events promoting things contrary to church teaching. And one organization tried to rent that space for an event promoting LGBTQ rights and same-sex relationships. The organization declined, and now they're facing a lawsuit under public accommodations laws saying that they're discriminating in the way that they're renting out their space. And obviously many churches have space that they rent to the general public. So this is a big issue for houses of worship. We're also seeing it with religious schools. One of the Becket Fund's clients right now is Fuller Theological Seminary in California. And they had two different students who, in violation of Fuller's community covenant and the clear admission standards, these students entered same-sex unions, and one was denied admission, and one had his admission rescinded. And those students have now filed lawsuits against Fuller Theological Seminary, alleging that they are discriminating on the basis of sex and sexual orientation. And this is not just at the seminary level. We're seeing these types of lawsuits at the college and university level, and we're also seeing it for admissions policies for religious schools in the K through 12 space. In addition to religious schools, we're seeing private lawsuits against doctors, clinics, and religious hospitals. There are a number of Catholic hospitals that have been sued by transgender individuals. So for example, a biological female who wants to transition to living as a male comes to a Catholic doctor or hospital seeking a hysterectomy so that this person can start transitioning to living as a male. Catholic teaching doesn't allow for sterilization or removal of a perfectly healthy uterus in support of a gender transition. So the Catholic hospitals have said, we can't do that here. You can get that done elsewhere, and they've been sued. And then lastly, counseling, childcare, summer camps, adoption, all these circumstances where houses of worship or other religious organizations are reaching out to provide services to the community, they all present a risk of offending individuals based on their view of marriage and facing private lawsuits. And the third major area where we're seeing private lawsuits is in the area of housing. So think of times when religious organizations provide housing. Homeless shelters, they've been sued. There are some women's shelters who've been sued by biological males who present as females and want to stay in the women's shelter, and the shelter doesn't allow that. They've been sued for gender identity discrimination. There are colleges and universities. They provide dormitories, and they've been sued by transgender individuals because they won't allow biological males to transition and live in their female housing. So that's just a quick overview of the types of private lawsuits and the major areas we're seeing those in employment, public accommodations, and housing. The other significant type of emerging conflicts are what I call government penalties. And in many ways, I think this is even more significant risk to houses of worship and other religious organizations. So what do I mean by government penalties? Here's a picture of Sharonelle Fulton. Sharonelle is a foster mom. She's been fostering for decades, and she partners in her foster care with a religious ministry called Catholic Social Services in Philadelphia. Catholic Social Services has been doing foster care ministry for over 200 years. long before the city of Philadelphia was ever involved. And basically what they do is they recruit loving families to provide homes for foster children. And then they surround those families with support. A couple years ago, the Philadelphia Inquirer newspaper published an article highlighting the fact that Catholic Social Services believes in traditional marriage and therefore doesn't place children in homes of unmarried couples or same-sex couples. Now, no same-sex couple had ever approached Catholic Social Services and asked for the help in this way. And if they had, Catholic Social Services would have referred them to one of over 20 different foster care agencies in Philadelphia that do place children with same-sex couples. So this wasn't a case where you had an aggrieved individual who was offended by Catholic Social Services. Instead, this was simply the city of Philadelphia saying, we think you are discriminating, we think that's bad, and we don't want to do business with you anymore. And so Philadelphia cut off its contracts with Catholic Social Services, and you can't do foster care in Philadelphia without a government contract. So this had the effect of shutting down this 200-year-old foster care ministry. We at Becket have sued the city of Philadelphia over this. It's gone all the way up to the Supreme Court, been argued in the Supreme Court, and we'll get a decision any day on whether Philadelphia can shut down Catholic Social Services because of its views about marriage. And so this Fulton versus Philadelphia case illustrates one type of government penalties. This is the area of contracts, grants, and loans. We've seen a number of these penalties on foster and adoption ministries. We're also seeing them emerge in the area of religious schools and vouchers. Many states and localities have voucher programs where parents can receive a voucher in order to have money towards private school tuition for both non-religious and religious schools. And we're increasingly seeing proposals and government actions that would condition vouchers and say you can't use these government vouchers at schools that quote unquote discriminate. And so that puts at risk many religious schools across the country that adhere to a traditional view of marriage. We're seeing this with doctors, clinics, and hospitals. One of my cases right now is representing religious doctors and hospitals who face the loss of all Medicare and Medicaid funding under an Obama-era rule now put forward by the Biden administration that would strip them of millions of dollars of funding unless they perform gender transition procedures in violation of their religious beliefs and medical judgment. And we're also seeing this problem with homeless shelters. Here's a picture of a woman named Julia Ward. She was a straight-A student in the counseling program at Eastern Michigan University, just one semester away from graduating. She had to counsel real clients under faculty supervision, and she was happy to counsel anyone on any matter, except that she could not in good conscience counsel LGBT couples in furtherance of a same-sex relationship. Instead, she would refer them to another counselor, which is commonplace in counseling practice. Unfortunately, Eastern Michigan University expelled her because of that, and she faced a lawsuit in order to get her degree. And this illustrates the other area of government penalties: licenses and accreditation. There have been a number of proposals at the state level to strip professional counselors of their licenses if they will not in good conscience counsel in furtherance of same-sex relationships. We've also seen threats to accreditation of religious schools. Gordon College in Massachusetts faced a threat to its accreditation over its views on marriage. And actually in Canada, British Columbia refused to allow a Christian university, Trinity Western University, to open a law school because the university had a community covenant that limited sex to marriage between male and a female. Third area of government penalties has to do with government jobs. So we've seen judges, magistrates, and social workers penalized. I represented a magistrate in North Carolina. The main job is swearing out warrants, but if there's no judge available, the magistrate can also actually perform a civil wedding ceremony. Excuse me. And my client could not, in good conscience, perform a same-sex wedding. And because of that, she was fired. So we're seeing government employees lose their jobs over their views on marriage. A fourth area is government facilities. The Boy Scouts have lost access to a number of different government facilities, government property, or government recreational areas because of their past view on human sexuality. And then lastly, another very serious area of potential government penalties is tax-exempt status. And if you watch the Democratic presidential debate, there were candidates who advocated for stripping religious organizations of their tax-exempt status if they adhered to a traditional view of marriage. And we've actually seen this with a religious organization in New Jersey, Ocean Grove Camp Meeting Association. They had an oceanside pavilion that was tax-exempt, and they rented it out for marriages. They could not, in good conscience, rent it out for a same-sex marriage. And so the government stripped their tax-exempt status for that oceanside pavilion. That's another very serious emerging conflict. So there you have it, a very fast 30,000-foot overview of emerging conflicts for houses of worship and other religious organizations, with the two main areas of private lawsuits and government penalties. So that's plenty of bad news. What about the good news? Let's start with some of the key legal protections for houses of worship and other religious organizations. Good news is we live in America. We have great religious freedom protections in America. We have the Free Exercise Clause of the First Amendment. That is what is protecting Catholic social services in the Fulton case, which we think we're going to win. Second, we have strong constitutional protections for church autonomy. This is for the rights of religious organizations to order their own internal affairs with their employees, their leadership, and their membership. We have a number of religious exemptions in federal, state, and local laws. An example would be Title VII, which governs employment law, has a broad exemption for religious organizations, and Title IX, which prohibits sex discrimination in education, also has a very important religious exemption, and that's at issue in both the Archdiocese of Indianapolis employment case, and it's at issue in the Fuller Theological Seminary case. And lastly, we have powerful civil rights laws that in many contexts protect religious freedom, most notably the Religious Freedom Restoration Act. That is the law that we at Becket asserted in defense of the Little Sisters of the Poor and Hobby Lobby, and prevailed on that law at the Supreme Court. And RFRA provides very broad protection for religious freedom. In addition to these legal protections, we also have been seeing a great decade-long trend of a winning streak in the US Supreme Court. Over the last decade, there have been 17 religious freedom victories in 18 religious freedom cases at the US Supreme Court. You may wonder what the one exception was, and that was the travel ban case. President Trump's travel ban against individuals from Muslim majority countries. And in many ways, that wasn't even litigated as a religious freedom case. It was litigated more as a political and an immigration case. So we're seeing major victories from the Supreme Court on religious freedom, covering all the various constitutional doctrines and the legal protections I mentioned before. We're seeing victories for people of a wide variety of faiths. Just at Becket, we've won Supreme Court cases on behalf of Christian, Muslim, and Jewish clients. There have been victories for Buddhist clients as well. And you might wonder how many of these are closely fought 5-4 victories. Well, not very many. There are only 4 of these 17 were 5-4 victories. 13 of these wins were by unanimous or supermajority vote. So we're seeing strong protection for religious freedom at the Supreme Court. I think the last piece of good news is that, in this conflict or potential conflict between LGBTQ rights and religious freedom really offers the most reasonable path forward. Our society is deeply divided, over matters of human sexuality and over marriage. And the question really is, what is the government going to do over our deep divisions? Is it going to pick one view of human sexuality and crush everyone who disagrees? Or is it going to try to find a path to allow everyone to live in accordance with their deeply held convictions? And religious freedom really offers the government the possibility of win-win solutions where LGBTQ individuals can still live their lives, they can still be married and still be full participants in society, but religious organizations as well can continue to live in accordance with their conscience and their deeply held beliefs, and the government doesn't have to penalize them for that. So here you see just a list of the decade-long winning streak in the Supreme Court, the cases there. I'm happy to say 7 of these are Becket Fund victories in the Supreme Court. And then the last piece of good news, which brings me to the third major goal for this talk, is that you can prepare for these emerging religious freedom conflicts. You don't have to just sit there and wait for the conflicts to come to you. There are practical steps you can take to reduce your risk. And so what are those steps? I think it's useful to think about these conflicts and potential threats as coming in 2 major ways. One is threats that come from within your organization, and the other is threats that come from the outside. Threats from within mostly have to do with employment disputes, your own employees maybe not being fully on board with your religious mission and suing or causing conflict from within. The other is threats from outside, when your organization is reaching out into the world, providing goods or services, and may have occasion to offend someone. Those threats are much more diffuse and varied, a little bit harder to prepare for, but I'm gonna focus a fair amount of attention on how to reduce threats from inside, and then just a few thoughts on threats from the outside. So as I mentioned, threats from the inside mostly have to do with employment. And first, you need to take steps long before you hire anyone. There are measures you can put in place. First up, religious organizations need to clearly define and communicate their religious mission within their organization. You do this at multiple levels. One is at the legal level in your articles of incorporation and your bylaws. Hobby Lobby, one of the Becket Fund's clients, did a really great job of this. It's part of why they won at the Supreme Court. Is even though they were a for-profit business, they made very clear in their organizing documents what their religious mission was, and so their religious freedom claims were taken very seriously. And then in addition to your legal documents, you also want to make your religious mission clear in your own job descriptions for your employees, your employee handbooks, and your employment policies. Second, long before hiring, you need to think about ways to cultivate support for your religious mission from top to bottom. It's not enough to just put it in your legal documents or put it in your employee handbooks. You need to actually cultivate support among your employees. You can do this through orientation or onboarding, making sure every new employee who comes to the door understands your religious mission and supports it. You can do it through ongoing training. You can do it through retreats that basically build out the culture of your organization and make sure everyone is on board with your religious mission. Second, when you're hiring, when someone's coming through the door, there are a number of important considerations. First up, you need to be clear in your own mind about what your faith requirements are. Some organizations will hire anyone of any faith or no faith at all. Others want some level of shared faith commitment, but they're not always clear about what level that is. Is it simply generally Christian or generally co-religionist? Do your employees have to agree to a specific statement of faith? Or do your employees have to be a member of the faith or a member of a particular church? And really there's a trade-off here where the looser your faith requirements are, the bigger your employee pool is, and you may be able to hire more qualified individuals. But when you're hiring from such a broad pool, you're also bringing potential religious freedom conflicts into your organization. And so the stricter your faith requirements are, the less likely your employees are to bring religious freedom conflicts to your doorstep. Second, during the hiring process, you need to have very clear articulation of the religious role. for each employee, and this should be reflected in their job title, their job description, and their duties. Like if you're expecting them to carry out religious functions within your religious organization, it's very important to articulate that to them, both so that they understand it and carry it out, and so that if there is a religious freedom conflict or a legal conflict in the future, it's very clear to the courts who's carrying out religious functions. You can also articulate these religious roles in the interviewing process, making sure your employees, your prospective employees, are fully on board. And you also communicate it during training, supervision, and evaluation. It's not enough to put in your job description. You need to clearly teach the faith to your students. You need to actually evaluate them and give them feedback on how they're doing that. And lastly, when hiring, it's very important to have clear expectations, not only for religious beliefs, but also for religious conduct. Are there particular actions that would disqualify you from carrying out this job? Are there particular standards that we expect you to live up to? If that's very clear to employees at the outset, you're less likely to face conflicts on the back end. So let's look at the back end. What happens when you have problems arise with your existing employees? How can you reduce risks there? Again, you need clear expectations for conduct communicated in advance. If an employee wasn't aware that their conduct was somehow violating your expectations, that's going to up the tension level very significantly. And second, you need very clear procedures for responding to violations of your conduct expectations, and to responding graciously and consistently. And I see a lot of missteps that religious organizations make in this area in a couple ways. One, I think some organizations look at employee misconduct mainly as an issue of organizational purity, where an employee violating standards of conduct is a threat to the purity of the organization and needs to be dealt with by immediately getting rid of the employee. Second, I see some organizations view misconduct more through the lens of what I think of as organizational reputation, where if an employee engages in misconduct but nobody knows about it, that's okay. But if it becomes public, if parents, if students find out about it, then it needs to be dealt with very harshly because it undermines the reputation of the organization. And I think there are places, of course, for caring about the purity and consistency of the organization, caring about its reputation. But in many cases, I think religious organizations would benefit from viewing these misconduct situations through what I call the lens of discipleship, where a misconduct is not met with an immediate get rid of the person for purity, or keep it secret and get rid of them only if it becomes public, but is instead viewed as an opportunity for discipleship, or in Catholic terms, it would be accompaniment. This is where someone is straying, and as an organization, compassion and commitment to our principles demands that we gently, humbly come alongside that individual and help them come back to the right way. Again, not every employee is going to be receptive to this, but I think it tends to reduce tension. For many religious organizations, it's actually more consistent with their guiding principles, and I think it also reduces the likelihood of a lawsuit. Relatedly, it's very important to keep first and foremost in your mind kind and fair interactions with employees. This is just, number one, it's the right thing to do, but secondly, it also reduces the likelihood of a lawsuit and also increases the likelihood of prevailing if you do face a lawsuit. And then lastly, it's very important when problems arise to get early legal advice. Many religious organizations take action and exert discipline without getting legal advice, and they step into a number of pitfalls when they do so. And getting a lawyer early can help you avoid a lot of those problems. So that's a very quick and fast overview of threats from the inside. I'm getting a little short on time, so I'll just be real quick on threats from the outside. There are measures you can take to, number one, assess your risks. Number two, to minimize the likelihood of conflict by considering the types of external ministry you engage in, who your partners are, reconsidering the scope of what you might object to or not, and in particular, reducing your reliance on ties with the government, whether that's government funds, government facilities, or any sort of dependency on the government. There's legal advice, again, early on can help you reduce threats from the outside. It's also important to kind of make a public case for your ministry. And the more you are indispensable to your community, the more you're a good citizen toward your community, the less likely the government is to want to shut you down. Religious organizations can also consider political involvement, but ultimately it's very important to stay true to your own religious principles and not do anything that really compromises your conscience in order to reduce your risk. So we've covered emerging conflicts. We've covered some good news of legal protections, covered a few practical steps you can take to reduce your risk. And now I'd like to offer just a few practical resources. What might your next step be? If I could take a moment for a quick plug, as Travis mentioned, I did write a book. It's called Free to Believe, The Battle Over Religious Liberty in America. And I wrote it precisely for audiences like this one, for leaders within houses of worship. It's not a legal tome. It's very much written at a layperson, non-lawyer level, and it's designed to help all Americans understand why religious freedom matters. Second, how it's threatened today. And then third, what you can do to protect it and to reduce your risk. And you can get that from Amazon or wherever books are sold. Second, there are a number of lawyers out there who can provide you with preventative legal advice. My firm, Becket, pretty much only litigates. So, we're in court trying to get into the Supreme Court. But, here's a former colleague of mine, Eric Niffen, is a partner at Lewis Roca in Colorado Springs. He counsels religious organizations all across the country before disputes arise. He can do an audit of your legal documents, make sure your house is in order before you face any conflict. So attorneys like Eric or others can provide you that advice you need early on. Lastly, if you want to keep up with developments on religious freedom, I'd encourage you to check out Becket's website at becketlaw.org. We have information on all of our cases and all kinds of cases that are affecting houses of worship all across the country. So thank you for your attention. I'd just like to end, we've covered a lot of bad news, but I'd like to end on a slightly positive note. And, the theme, the theme verse for my book, Free to Believe, I'm a Christian, I took it from John 16, where Jesus says, in this world, you will have trouble. And I think when it comes to religious freedom, we will see more trouble in our country in the coming years than we have in the last decade. There are new conflicts that are emerging, and you may be involved in a religious freedom dispute, even though you don't want to be. So in this world, we will have trouble. But in the very next breath, Jesus said, "Take heart, I have overcome the world." And there are many, many reasons for confidence and for good news when it comes to religious freedom. I went through all the legal protections and the great victories in the Supreme Court. And the reality is we do have a strong legal system here that is deeply committed to religious freedom. And we are winning a lot of cases. The Becket Fund has, across the last quarter century, we have a 90% win rate across all of our cases, and we're undefeated at the Supreme Court. So all is not lost. Even at the practical level, we have strong protections for religious freedom. But if you're a person of faith, and particularly if you are a Christian, as I am, we also recognize that our hope is not simply in man-made legal institutions, and our ultimate hope is not in winning election or winning the next Supreme Court victory. We have a hope that transcends that because we worship a risen Savior who has conquered death and conquered sin. And so even if we face a religious freedom conflict, and even if we lose our rights, that is not the end of the world. That's an opportunity for our testimony as well. So I just want to leave you with that word of hope and word of encouragement. And with that, I look forward to your questions.
All right, thanks, Luke. We got some questions here. We'll try to knock these out. Question, is there any protection for the organization from malicious intent of those who seek accommodations with the intent of being denied to declare discrimination? So I guess in a nutshell, the question is if somebody has the intent of being rejected or denied solely for the sake of filing a suit.
Yeah, so we have seen cases like that. If you're familiar with the Masterpiece Cake Shop case that went up to the Supreme Court, a Colorado cake artist who was sued and threatened because he declined to design a cake for a same-sex wedding. He's faced repeated attempts by people who are simply trying to provoke conflict, coming to his store, asking for cakes that they know he cannot in good conscience design, and then drag him into court over that. So that is a reality. We've seen it in practice. I'd say, there's nothing you can do to stop people from engaging in that sort of conduct. But I think that conduct also comes through. If you end up in court, it can become quite evident what was really going on here. And really what religious organizations need to do, number one is, consider what lines of business or what lines of ministry you're going into. Are you offering the types of services that invite that sort of trolling or invite that sort of invitation to conflict? And are there ways that you can adjust your outreach that minimizes that risk? And early legal advice can be very helpful in that regard. And then secondly, how are you conducting yourself in the midst of those interactions? And I go into this a lot more detail in Free to Believe, but really, if you're a Christian, what does it mean to be Christ-like in the midst of this? What does it mean to love your enemies? What does it mean to seek peace and pursue it and seek to live at peace with all men? And I think the way that we present ourselves in public, whether through our ministry or through our business, and presenting ourselves with kindness and humility and graciousness is really what goes the longest way, both to reducing the likelihood that people want to create those conflicts, and then if you do end up in court, reduces the likelihood of an adverse ruling.
Great. Okay. What, if any, potential snags do you see with the impact of the Equality Act regarding federal protections in religious organizations?
Great question. So the Equality Act is legislation that's been proposed in Congress and passed the House, and it would dramatically expand protections in federal law against discrimination based on sexual orientation or gender identity. And it applies to employment, it applies to public accommodations laws, it applies to education. And so without getting into the nitty-gritty details, what the Equality Act would do is basically ratchet up all of the conflicts I mentioned, both the private lawsuits in employment, in public accommodations, and in housing, and also ratchet up the potential justifications for government penalties, such as denial of government contracts, licenses, grants, accreditation, government facilities, and tax-exempt status. So the Equality Act is very bad news. Another pernicious part of the Equality Act is that it says that the Religious Freedom Restoration Act, RFRA, doesn't apply to Equality Act violations. And that would be the first federal law that ever kind of exempts itself from the Religious Freedom Restoration Act. So it sets a very bad precedent and also reduces the legal protections available to houses of worship and other religious organizations. So not pulling any punches, the Equality Act is very bad news, would increase conflict. Good news is, one, it hasn't passed yet. And number two, it doesn't eliminate the Constitution. And I do think there are ways that litigation under the Equality Act can still provide religious organizations with very significant protections for religious freedom.
Thank you. Can you say more about what you can or cannot put in a job description? And basically, as a church, I think this is a two-part. I'm going to put these two questions together. As a church, can you actually require someone to hold your faith in the job description? Or is it enough to ask people to have a background for or an interest in your faith tradition in the job description?
Great question. This is one area of the law where the law is crystal clear. at least certainly at the federal level. The federal law that prohibits employment discrimination has a broad religious exemption, and it says that Title VII does not apply to religious organizations with respect to the hiring of individuals of a particular religion. And so if you want to, and there's a 9-0 Supreme Court case on this called Corporation of the Presiding Bishop of the Church of Jesus Christ of Latter-day Saints, where the LDS Church actually said, we won't hire anyone to work at this religious organization unless you have a temple recommend. And that's basically like a certificate of good standing within the Mormon Church. So if you wanted, as a church, you could say, we won't, if you're a religious organization, you can say, we won't hire anyone who is not a member of First Baptist Church of San Diego, or we won't hire anyone who doesn't agree with our 14-point statement of faith, or we won't hire anyone who isn't a member of a Christian faith. It's crystal clear. You can require, you can have very strong faith requirements in your hiring. Where the law gets a little grayer, or where there's ongoing conflict right now, is over standards of conduct. So you can clearly say you have to be a Christian, but can you say you have to be a Christian and you have to refrain from sex outside of marriage, or you have to refrain from making terribly bigoted remarks against immigrants, or any other standard of conduct you might want to impose? And this is what's going on in litigation right now in the Archdiocese of Indianapolis case. And I think long term, I think courts are ultimately, in most cases, are going to say that religious organizations can impose standards of conduct on their employees. And particularly if you are clear about articulating those up front, and you are consistent and compassionate in the way that you enforce those, you're generally going to be okay. I think where the biggest risk comes in is if organizations are not clear about what their standards of conduct are, if they're inconsistent in the way that they enforce those standards of conduct, or if they're targeting specific types of conduct. For example, if you're a church and say you're running a school and you have a teacher at your school, a female teacher who is pregnant and unwed, and you take action against that teacher. But the male gym teacher also got his girlfriend pregnant, and you don't do anything to the male teacher. Courts are going to really delve into that if you're being inconsistent and it looks like you're targeting one group over another. Again, you may still have protections, but that's where you have the greatest risk.
Great tie into that question was, what about volunteers? So same standards as employees, or how do you handle volunteers that maybe work in, or maybe not even church members, but work your community events, work on your behalf?
Yeah, so that's a hard one to answer in the abstract. I think standards for volunteers, it'll depend very much on the context. Is it a volunteer in terms of like ushering at a church on Sunday? I'd say you can do whatever you want. Is it a volunteer where you're out in the community providing services to the homeless, and it it looks more like a business setting? There might be harder questions. But in general, you're going to have more freedom to set standards for volunteers than you do for employees, because without an employment relationship there, employment laws don't kick in. And so the only laws that you'd be looking at are probably more like public accommodations laws. And so the more business-like it looks like, the more there may be an issue there. But in general, if you're carrying out a religious mission and you're relying on volunteers to do that, you have very strong grounds for saying we're a religious organization with a religious mission, and we need our volunteers to uphold our core religious beliefs and practices.
Thank you. There was a question about the Supreme Court and the decade of 17 out of 18 wins for religious freedom. And it was a two-part question. One was, do you think that's attributed to the Supreme Court having a conservative majority? I think you mentioned that 13 of those 17 cases were, I don't know what the word you use, supermajority or 9-0 votes in that regard. So that's Interesting. And did you have an opinion on the attempt to expand the Supreme Court?
Yeah, so addressing the first point first, there's a perception that all of these religious freedom cases are hotly divided, 5-4 decisions, but they're not. One of the most important religious freedom victories was in 2012, a case called Hosanna Tabor. And that was a Becket Fund case where we represented a Lutheran church, which ran a school, and the Supreme Court affirmed 9-0 their right to determine who could teach at their religious school. We had another victory just last term in a church in a case called Our Lady of Guadalupe. Similar issue, Catholic school employing teachers there, and that was a 7-2 victory. So we've seen a lot of not even close victories for religious freedom. I think the one caveat there with the positive story would be, less about how closely divided it is and more along the lines of like, I wish we didn't have these religious freedom conflicts to begin with. Like the fact that we won a supermajority victory for the Little Sisters of the Poor. That's great. But the Little Sisters of the Poor never should have had to litigate for 7 years over the government's requirement that they use their health insurance plans to provide coverage for drugs that can cause an abortion. So the flip side of all these victories is some of these cases never should have arisen in the first place. And then second question was about expanding the Supreme Court. That's more, I think, of a question of politics, but obviously I think that would be very bad for the Supreme Court as an institution and would be unnecessary. Fortunately, I don't think it's all that likely to happen.
Great. What about, I don't know if you've been involved in religious freedom versus government COVID-19 restrictions. What are some things to be considered when making decisions around that? It's kind of hopefully becoming less and less of an issue as we come back to normalcy, but go ahead.
Yeah, we could do a whole another 45-minute webinar just on the COVID litigation, but we have been deeply involved in that litigation. We actually won the first Supreme Court victory in COVID litigation, the Diocese of Brooklyn case, along with our client, Agudath Israel. We represented Orthodox Jewish synagogues against Governor Cuomo's targeted restrictions against synagogues. But I think if I could paint with a very broad brush about COVID, I think what you've seen over time, right at the beginning of the pandemic, when there was so much uncertainty about the nature of COVID-19 and so much uncertainty about how it spread and so much uncertainty about the public health effects of it, you saw governments clamp down quite a bit, including on worship. And I would argue in many ways, unnecessarily stringently against houses of worship. And in the abstract, I think if you treat houses of worship perfectly equally with other types of gatherings, and you're doing it right at the beginning of the pandemic when there's a lot of uncertainty, maybe that can fly temporarily. But as the pandemic wore on, as we learned more about it, and as the restrictions wore on, I think the government bears a much higher burden of proof to keep those restrictions in place. And I think you've seen that accordingly in the courts where, first early on, the courts were more willing to countenance those types of restrictions on worship. I think when we got that victory in the Diocese of Brooklyn and Agudath Israel case, that was on the night before Thanksgiving. It was almost, I think it was like 11:30 at night, the night before Thanksgiving. The Supreme Court issued that first order striking down New York's restrictions on houses of worship. I think that kind of opened the floodgates, and the Supreme Court since then has consistently struck down these restrictions on houses of worship, particularly when they're treating other types of gatherings more favorably than they're treating religious gatherings. And concomitantly, you've seen states pretty rapidly dropping their restrictions, where I think now there's only 4 states right now with restrictions on houses of worship, and they're much looser than they were early in the pandemic. And I think it's only a matter of time until those get lifted as well.
Great, thanks. We've got time for one or two more. And if possibly, maybe offline, some of these questions Luke might be able to answer for us and get back to you, those that have asked them. I will say there are a couple here. One was about the information presented today. That will be posted to our website and sent out to those that attended today. So I just want to remind you of that. There was a question, quick question about a sexual offender. I will remind you that, not remind you, tell you, maybe you've got the email already, but we are having a sexual abuse prevention webinar May 18th. So save that question for then. We'll do what we got time for, maybe one or two more. Question, with the PPP and security grants available by the government, should these be on the list of items to avoid to reduce reliance on government funds? If so, can you explain why?
Great question. So the first couple rounds of PPP funds have not had any sort of strings attached that I have heard that have inhibited religious organizations in the way that they're carrying out their religious mission. So I think it's a matter of conscience for different religious organizations. Different organizations have different views about the degree to which they can accept government benefits or government funds. But from a strictly religious liberty perspective, I have not seen any strings yet on those PPP funds that inhibit religious freedom of religious organizations. So I think the main, that said, I wouldn't say it's entirely risk-free. And the way that I think it creates potential risk is what I think of as habituation, or the creation of dependency. And you can accept government funds, but the more that you become reliant on those government funds, the more you are in a position of significant danger. And I'd say an example of this would be in the context of religious schools. There are a number of states that have vouchers or tax credits that can be used at religious schools, or even California has Cal Grants for higher education, which students can take and use at religious schools. But the more that religious schools accept government funds, the more the risk they become dependent on government funds. And I do think you will see in the coming years, more and more governments will attach strings to vouchers, to tax credits, and to other forms of government funds that will put religious organizations to a very hard choice. Do you want to violate your religious convictions, or do you want to have the government funds? And if you're dependent on government funds, that choice is going to be even harder.
Great. Okay, we'll do one more. Somebody asked about a webinar on potential risk with COVID-19. You can check out our website, ccia.com. We have done some webinars on COVID-19 and risk, so check that out. Last question was about state-by-state requirements for job descriptions for religious organizations. Do you see differences in state by state, what you cannot put in a job description?
There are, not so much with job description, there are definitely very significant state-by-state differences. And that's why it's important to get early legal advice. There are state laws have a different level of protections for employment laws for religious organizations. They also have different types of public accommodations laws. And so, whereas my practice is nationwide and I'm mostly in federal court looking at federal law, their religious organizations do need to look closely both at state and local laws for ways that it can vary, both with regard to employment and public accommodation. And that's where getting local legal advice can be so important. Travis, I think you muted.
There we go. Thank you. The question of you're muted continues into 2021. Luke, I want to thank you for your time today. Appreciate it. Thank everyone for attending. There was a question about insurance. Please reach out to us if you're uninsured with us. We can talk you through the religious freedom coverage you have. If you're not, we can talk about that also as well. So ccia.com or hello@ccia.com is the easiest way to reach us. And Luke, again, thank you for your time. And those questions we didn't get to, we'll see if we can have Luke maybe help us out and answer a couple of those and get back to you individually on those. Thank you all for attending, and have a great rest of your day. Thank you, Luke.
Thank you.